5, 4, 3, 2, 1.
This video is a complete training on how MERP deals work from start to finish and how they can adversely affect real estate closings. I am UC AI, an AI avatar of Uncle Charles, created by REI Labs for the UNC 360 REI Codex School. Every state in the country participates in Medicaid, and under federal law, every state is required to operate some form of Medicaid Estate Recovery Program, commonly referred to as MERP. While the rules vary by state, the authority is federal, and the impact on real estate transactions is nationwide. MERP is one of those things most investors never hear about until it shows up at title and kills a deal they thought was done. And by the time most people learn what it is, it's already too late. MERP does not begin with real estate. It begins years earlier, quietly, inside the healthcare system. A homeowner gets older. Health declines, long-term care becomes necessary. At some point, Medicaid steps in to pay for nursing home care, assisted living, or other qualifying medical services. These benefits are often paid over long periods of time and can easily total tens or even hundreds of thousands of dollars. During this time, families are focused on care and survival. No one is thinking about estate recovery. No one explains that Medicaid is needs-based, and almost no one explains that benefits paid may later be subject to recovery after death. But the government is tracking everything. When the Medicaid recipient passes away, the legal landscape changes immediately. An estate is created. Heirs step forward. Property transfers are discussed. And this is when the state Medicaid agency begins its estate recovery review. If recoverable Medicaid benefits were paid, the state issues what is commonly called a MERP notice. This notice informs the estate or heirs that Medicaid benefits were paid, states the total amount claimed, and asserts the government's right to recovery. This notice is not a foreclosure, it is not a lawsuit, and it is not automatically a lien. Legally, it is a claim against the estate, not a recorded encumbrance against the property. This distinction matters, but unfortunately, it is also where most people get confused. A lien is a recorded instrument that attaches to title and must be satisfied before a property can transfer. A MERP notice, by itself, is different. It is not a recorded lien. It is simply notice that the government may seek recovery from the estate. But title companies do not operate on legal nuance. They operate on risk. Once a title company determines that an owner has passed away, they begin asking questions designed to eliminate future exposure. One of those questions is whether Medicaid benefits were paid and whether estate recovery applies. If there is any indication that Medicaid may be involved, the title company will contact Medicaid to determine whether a claim exists. If Medicaid confirms that benefits were paid and that a balance is owed, what we call a positive MERP, Medicaid will issue what is commonly referred to as a MERP notice. From a risk standpoint, the title company cannot insure over a potential government claim. Once a positive MERP exists, title companies assume the government has the legal authority to enforce that claim. And legally, that assumption is correct. Under federal and state law, Medicaid has the ability to assert claims against estates and pursue recovery if necessary. Title companies do not wait to see whether enforcement will occur. The existence of that authority alone is enough to stop a closing. That is why positive MERPs freeze real estate deals, even when no lien has been recorded. Under federal and state law, Medicaid agencies have the authority to assert claims against estates, reduce or block distributions to heirs, file lawsuits to recover benefits, and in certain circumstances, pursue enforcement actions that affect real property. Because of this authority, title companies do not wait to see if enforcement will happen. They assume it can happen, and they refuse to insure. This is why title companies request MERP clearance. It is not because a lien exists. It is because the risk exists. And once title refuses to insure, closings stop. This is the moment where most deals die. Realtors say the property can't be sold. Wholesalers abandon the deal. Investors move on to easier transactions. Attorneys don't want the file, and the heirs are left stuck with a property they thought they inherited but can't sell. Most heirs don't have the cash to pay the claim. They don't understand the process, and time is now working against them. Taxes accrue, properties deteriorate, pressure builds. This is where most people lose, and this is exactly where opportunity is created. Here is the part most investors never learn. Only a small percentage of MERP claims ever become recorded liens. Industry data shows that roughly 10 to 20% of MERP claims are ever formally enforced through recorded liens or court action. Most MERP claims are negotiated, reduced, deferred, waived, or never pursued to enforcement. But title companies do not underwrite probability. They underwrite worst-case exposure. That is why positive MERPs kill deals, even when resolution is possible. Most states also allow MERP hardship waivers. These may apply when an heir lived in the property, when a disabled or dependent heir exists, when recovery would cause financial hardship, or when the estate is insolvent. However, most waiver requests are denied, not because waivers don't exist, but because they are time-sensitive, documentation-heavy, and procedurally strict. Most are filed incorrectly or too late. This is why heirs lose. This is why investors give up. And this is why MERP deals exist as a category of opportunity. MERP deals are not bad deals. They are misunderstood deals. They involve death, estates, government authority, title refusal, and fear. And because of that, most people avoid them. When everyone walks away, pricing collapses. Not because the property lacks value, but because the problem is misunderstood. This is where experienced operators step in. MERP deals are not about one exit. They are about creative real estate exits. Sometimes the exit is a wholesale or wholetail. Sometimes it is a structured assignment. Sometimes it is a subject to transaction. Sometimes it is a multi-stage creative acquisition. The exit does not define the deal. The problem defines the deal. That is why we simply call them MERP deals, regardless of how they exit. This is exactly why Uncle Charles built the UNC 360 REI Codex School, powered by REI Labs and the RE AI system. The Codex is being built to teach how MERP deals are actually handled, how title risk is managed, how creative exits are structured, and how complexity is turned into profit. Let me give you a real example of why understanding MERPs matters. One of our most complex MERP cases produced almost $100,000 in profit, not because it was easy, but because we knew exactly what we were doing. This property had everything working against it: a death estate, heirship problems, non-paying occupants and squatters, gang activity, no utilities for over 3 years, no access, nearly $50,000 in delinquent taxes, a tax foreclosure pending. And on top of all of that, Medicaid issued a $158,000 estate recovery notice, a MERP. Every realtor, wholesaler, investor, title company, and attorney walked away. We didn't. We took control early, navigated the estate and MERP issues, closed the property as is, and executed a wholesale strategy. We closed twice, first through a creative internal assignment, then on resale. We first had the heir place the property into a trust, held it for a period of time, then funded the internal assignment with a hard money loan. We cleared the property through eviction in court, had it forcibly vacated by the sheriff, cleaned it with no rehab, listed it on the MLS, and sold it using a wholesale exit. That's almost $100,000 from one deal. This is why MERPs aren't bad deals. They're misunderstood problems, and problems are where the money is. Here is a full summary of how a MERP situation works from start to finish. Medicaid benefits are paid during the homeowner's lifetime. Those benefits are tracked by the state. The homeowner passes away, an estate or heirship situation is created. If there is a debt owed, Medicaid issues a MERP notice stating that the debt is owed. The notice is sent to the estate or the heirs. If a title company requested the MERP confirmation, Medicaid will also send the notice directly to the title company. The notice is not automatically recorded as a lien. A positive MERP simply means a balance is claimed. However, title companies treat the notice as if it were a lien. Title refuses to insure. Closings stop. Most investors walk away. At that point, the deal either dies or it is handled correctly. It is important to note, when a MERP notice is issued, it is not coming from the federal government directly. It is coming from the state Medicaid agency, acting under federal mandate. Medicaid is a federally mandated program, but the benefits are tracked, administered, and recovered by the state. If this video helped you understand MERPs, subscribe to the UNC 360 Real Estate Reimagined YouTube channel. More real, detailed breakdowns are coming. If you want to learn how these situations are actually resolved and monetized, look for the UNC 360 REI Codex School, launching in 2026, powered by REI Labs and the ARI AI system. The next video will break down how MERP situations are turned into profit. Keep it simple, keep it crisp, keep it honest. Subscribe now, and I'll see you in the next video.